Hello aspirants, welcome to Introspection IS. So as we have started a series of discussion of previous year question paper with respect to polity. So in this series we are going to start a new topic, that is a fundamental rights. So we'll discuss in this series the previous year questions asked in polity on a basis of fundamental right on the topic. Clear? So let's start discussion. So the question asked in 2024. So the question is that under which of the following articles of the Constitution of India has the Supreme Court of India placed the right to privacy? So now this question says that through judgment the Supreme Court has put right to privacy under which of the following articles. So if you see the article, so article 15 talks about the prohibition of discriminations. Prohibition of discrimination. Discrimination. So the state cannot discriminate among citizens of India, among citizens, right? Now the ground is also mentioned under this. So it says that the citizen of India cannot be discriminated on the basis of religion, race, caste, sex, or place of birth. So this right to privacy is not under Article 15. Now Article 16 talks about Article 16 again talks about a prohibition of discrimination by state on public employment, right? Now this discrimination is also on the ground similar to that of an Article 15, including the one more ground included under the Article 16, that is a place of residence is included in Article 16. So this is not also under Article 16. Now Article 19 of the Constitution talks about a freedom of speech and expression. Freedom of speech and expressions. So this talks about a freedom of speech. So this is also not under Article 19. Now Article 21 of the Constitutions that talks about the right to life, right to life and personal liberty. Personal liberty. So this right to privacy is basically related to individuals and it is personal. So the while interpreting the Article 21 of the Constitutions, the Supreme Court has put the right to privacy under Article 21. So our answer is D to these questions. Now if you see the judgment under which the Supreme Court has decided the right to privacy under Article 21, the case was Justice K.S. Puttaswamy, retired justice versus Union of India 2017. Also known as a right to privacy verdict, was a landmark Supreme Court of India case that established right to privacy as a fundamental right. So through this, under this judgment, the Supreme Court has established that right to privacy is also a fundamental right. The Supreme Court recognized that right to privacy as a fundamental right protected under Article 21. The court held that privacy is an essential aspect of personal liberty and dignity and is intrinsic to the entire constitutional schemes. The bench also ruled that the right to privacy is not absolute but is subject to reasonable restrictions. So through Puttaswamy judgment, the Supreme Court put the right to privacy under the right to life and personal liberty. Clear? So this was this was asked in 2024. Now let's move to the next questions. So next question was also asked in 2024 and this question is related to writ of a Supreme Court, the power of Supreme Court to issue writ. So the question says a writ of prohibition is an order issued by Supreme Court or High Courts too. So this is basically asking about the nature of writs of prohibition, right? So before discussing these questions, let's see what is writ. So if we talk about a writ, So writ is an writ issued by Supreme Court for violation of fundamental rights under Article 32, and writ also issued by High Courts for violation of fundamental rights plus other legal rights through Article 226. So Supreme Court empowered by Article 32 to issue writs with respect to violation of fundamental rights, whereas whether high courts were empowered by Article 226 to issue writs for the violation of, not only for the violation of fundamental rights but also for the violation of other legal rights. Now the type of writ which is mentioned in the Constitution, there are five types of writ. The first is habeas corpus writ, the second is mandamus, the third is prohibition, the fourth is certiorari, and the last is quo warranto. Clear? So these are the five types of writ mentioned in constitutions. So constitution specifically mentions under Article 32 about the five types of writ. Now this habeas corpus means to have a body, to have a body, right? Now here the question is about the prohibition writs. So we'll more focus on the prohibitions, but to understand the prohibitions we'll make a comparison between these three of the writs: mandamus, prohibitions, and certiorari, right? Mandamus, the literal meaning of the mandamus is to command, or the literal meaning of prohibition is to forbid. The literal meaning of the certiorari is to certify, and the literal meaning of quo warranto is by what authority. Clear? So here we are going to more focus on prohibitions because the question is based on prohibitions. So prohibition says to forbid. So this prohibition, now if we compare the mandamus and prohibitions, so mandamus is basically a command, that is it is asking something to do. So through mandamus, the court asks someone or institutions to do something. To do something. It means it is having an asking for activity, right? Whereas the prohibition is forbid. It means it is acting. It is asking not to do not to do. So this in the real sense we can say this is asking inactivity. It is stopping someone from doing something, but mandamus is asking someone to do something. Now this prohibition is basically issued to keep the lower courts, it is only issued to the judiciary or quasi judicial body, so to keep the lower court under its jurisdictions under its jurisdictions. Whereas mandamus is issued against a public office, right? And prohibition is issued on the lower court, judiciary or quasi judicial body. Now if you see the certiorari, so it is an extension of a prohibition, where prohibition is asking inactivities to do, keeping someone from to do nothing and limit and keeping it within its jurisdictions. Certiorari is to certify that, suppose it is also issued against a lower court or judiciary or quasi judicial body, right? Now this is also issued, the same purpose is that, so to keep the judicial body, under jurisdictions, right? Now this prohibition is issued during during trial, before the judgment made, right? Whereas certiorari is issued after trial and judgment made, and after the judgment given by the judiciary, given by the court, right? So this is prohibition and certiorari. Now if we go to the options, so let's see, analyze the options. So first options, the question is about a writ of prohibition is order issued by Supreme Court or High Court, to which authority, right? So does the prohibition issued against a government officials? No, as we have seen, prohibitions and certiorari is only issued to judicial body or a quasi judicial body, so it is not against a government official, so this cannot be our answer. Does it issue to parliament or legislative assembly? No, it is also not been issued to the parliament or legislative assembly to pass a law on prohibition. No, right? uh, C, the lower court prohibiting continuation of proceeding in a case. Yes, this can be an answer. Now let's analyze the last options. Issue the government prohibiting? No, it is not issued against the government. So yes, our answer is C, and the C says that the lower court prohibiting continuation of proceeding in a case. It means this prohibition is issued during the trial, which we have seen, during the trial before the judgment is passed. So we can say that this is just to issue the objective of the prohibitions, and so is the same, just to keep the judicial body or quasi judicial body under its jurisdictions. Is it clear? Now let's discuss the prohibitions separately. So according to Article 32, the Supreme Court can issue writs such as habeas corpus, mandamus, prohibitions, quo warranto, and certiorari. This we have seen. Now prohibition means to forbid. A writ of prohibition is a judicial order that prevents a lower court from interfering with a higher court's determination of case. It is issued by higher court to prohibit a lower court from. Now, when it can be issued against a lower court? So first, the condition is that issuing order over matter it has no jurisdictions. So it means keeping the lower court within the jurisdiction. Next, relitigating issues that have already been decided by the higher court. It means again it is, if any matter which has already been decided by the higher court, and if it is again issued by the lower court, again it beyond its jurisdictions. Acting without or in excess of jurisdictions, violating rules of natural justice, contravening fundamental rights. It means this fundamental right does not come under the jurisdictions of lower courts, so they cannot issue writs with respect to the fundamental rights. So basically, the prohibitions, a writ of prohibition is issued only to keep the lower court or judicial body within its jurisdictions. So the lower court does not exercise beyond its jurisdictions. Clear? So this is question number second. Now let's move the next questions. So the next question talks was asked in 2023. This is also a conceptual questions, concept based questions. So the question says, in essence, what does the due process of law means, right? Now this due process of law, before answering the questions, we need to understand what does the due process of law and what is its origin. So if we see the, according to Article 21 of the Constitution, which says that, and Article 21 of the Constitution talks about the life and personal liberty, and it says that no individual can be deprived of his life and personal liberty, of his life or his personal liberty, except procedure established by law. So this is the Article 21 talks about. Now this due process of law has not been mentioned in the constitutions, not defined in constitution, and not mentioned in constitution. Right. But this due process of law used by judiciary judiciary to interpret the article 21 of the constitutions, right? Now if we see what is the difference between procedure established by law and due process of law. So the procedure established by law means, and due process of law. Now procedure established by law means that, suppose that, as we know that Indian Parliament has a power to legislate, and by, suppose that by using the power of legislation, the Parliament can make any law, and this law, and through this law, it takes anyone's away anyone fundamental rights, right? So it means through legislations, if through legislation Parliament takes away anyone's fundamental rights, so the judiciary cannot call unconstitutional the law, because the action of a legislature has been defined through the article 21, that individuals liberty cannot be deprived, a persons cannot be deprived of his life and liberty except procedure established by law. It means article 21 says that through law, through legislations, the parliament or the state legislature and the state can deprive anyone's liberty, but without except other than the law, that individual rights cannot be deprived him. So this is a procedure established by law, and this was case until before 1978. That is before Menka Gandhi case, which was decided by the Supreme Court. Now this due process of law come into the picture from Menka Gandhi case. From Menka Gandhi case, in which the judiciary says that not only the law should be passed by legislature, the concerned legislature, but also the implication of law should be just and fair. Just and fair. It means that is based on natural justice. Natural justice. This was decided in Menka Gandhi case, and through this case, the Supreme Court has tried to establish a due process of law from the American concept, American judicial concept. Clear? So this is due process of law. Now when we come to the questions, so it says in essence, what does the due process of law means? So the first is principle of natural justice, the procedure established by law. Now this is opposite to the due process. Fair application of law, equality before law. This is also not equality before law. Now the answer is principle of natural justice, but there is a confusion between A and C, and most of the students has opted for the fair application of law as a correct answer to the due process of law. This is also correct, but as we know that in UPSC we need to choose the most appropriate answer, and among the two, that is A and B, the most appropriate is principle of natural justice. So the answer to this question is principle of natural justice. Is it clear? Now let's see the concept of Article 21. So according to Article 21, the protection of life and personal liberty, which says that no person shall be deprived of his life or personal liberty except according to procedure established by law, right? Now, what the definitions of procedure established by law given by the in AK Gopalan versus State of Madras in 1950. Now, the if we see the background of the case, so the AK Gopalan was arrested by the Madras government under Preventive Detention Act, right? So the background of the arrest or the reason for his arrest under the Preventive Detention Act, and this act was formulated by the Madras government, right, which says the procedure established by law. So he cannot be deprived of his life or personal liberty except according to procedure established by law. So if a legislature through law can empowered by the 21 to deprive anyone his life and personal liberty. So this law was challenged by A.K. Gopalan in Supreme Court, where the Supreme Court under A.K. Gopalan and State of Madras in 1950 has interpreted the procedure established by law, and we can say that the Supreme Court has narrowly interpreted this procedure, right? Now let's see what the case what are the judgment in this case. This case is also known as a preventive detention case. Why? Because the Eko Gopalan was arrested under Preventive Detentions Act. It is a landmark case in Indian constitutional law, deals with the interpretations of key fundamental rights under Article 19 and 21 of the Constitutions. Article 21, which covered procedure established by law, would simply means to establish by the state. So this was interpreted by the Supreme Court, which says that procedure established by law means if the state through legislation has established any law, that law is empowered by 21 to take away anyone's life and personal liberty. The Supreme Court determined that there is no relations between Article 21 and 19 of the Constitutions. Court ruled that Article 21 of the Constitution did not requires Indian court to apply a due process of law standard. So this was a narrow interpretations of procedure established by law. But again, this was challenged in Menka Gandhi case in 1978, when again the Menka Gandhi was forced to surrender her passport, and under and she was restricted to travel to foreign travel. She was restricted. So she challenged this in Supreme Court. Now, through this case, the concept of due process of law was established, and the Supreme Court then, from 1978, started to apply the due process of law while interpreting Article 21. So, in this case, the Supreme Court overruled the A.K. Gopalan's case. So the nullify or whatever the judgment given in A.K. Gopalan while interpreting the procedure established by law, the Supreme Court under Menka Gandhi has overruled that and held that mere prescriptions of some kind of procedure is not enough to comply with the mandate of Article 21. So it means that it says that only if the law made by legislature is not enough, its implication has also been seen. Is implication has also to be seen, whether the law is just and fair, whether it is uh, qualify the natural justice or not. So the procedure prescribed by law has to be fair, just and reasonable, not fanciful, oppressive or arbitrary. Otherwise it would not be a procedure at all, and all the requirement of Article 21 would not be satisfied. Natural justice is intended to invest law with fairness and to secure justice. Law should be reasonable law and not enacted piece of law. By accepting the concept of natural justice as one of the essential component of law, it is submitted that the court has imported the American concept of due process of law into our constitutions. So, though the due process of law has been now from 1978 onwards, Supreme Court used the due process concept while interpreting the Article 21, but it has not been mentioned in Article 21, and 21 is not been amended. So language of the Article 21 is similar to its original constitutions, but while interpreting, the court used the due process of law. It means it is analyzing whether the law is made is based on natural justice or not. So not only it is enough for the legislature to formulate a law, but that law has to be just also, to fair also, and that has to be a reasonable also. It means its implication has to be a fair. Clear? So this was decided by the judiciary. Clear? Let's move to the next questions. So next question was asked in 2022. This is again a writ which we have already discussed the types of writs. So it says that with reference to the writs issued by the court in India, consider the following statement. So here we have already seen the writs type of writs. There are five types of writs. So in this questions, basically the writs is about the two types of writ has been asked, mandamus and Q warranto, right? So it says that now we need to see and we need to find a correct answer. So it says mandamus will not lies against a private organization unless it is entrusted with public duty. Yes. So out of the five, here we need to discuss mandamus. Mandamus, the literal meaning is to command, to give order, to ask someone to do something, and it only issued against government or a public nature office. It cannot be issued against private with individual or private organizations or body. So the first is true that mandamus will not lie against a private organizations unless it is entrusted with a public duty. So if it is issued against a private organizations, it means that private organizations have some that is quasi, that private organizations quasi public office. A public duty has to be there. Unless and until any office or an individual does not entrusted with a public duty, so mandamus cannot be issued against this. And one of the features of this mandamus, this mandamus, writ of mandamus is discretionary of High Court. So it is up to the High Court whether the High Court can issue mandamus or not. So it is a discretionary of High Court to issue mandamus. So it means the High Court can deny the issue of mandamus. It's clear? So first is true. Now second, mandamus will not lie against a company even though it may be a government company. No, if you see the first and second, the second is contradictory to first. Why? Because the first says if the private against a private organization the mandamus has to be issued, so it should be trusted with public duty, right? So it unless and until the public duty is entrusted to private organizations, mandamus cannot be issued. But it's saying that the second is contradictory, where it says that mandamus will not lie against a company even though it may be a government company. So if a company having a public duty, so yes, mandamus will be issued against that company. So second statement is incorrect. Now if we go to the options, go through the options, so the second is incorrect. So 1, A, B and D is our incorrect. So we are left with the C. So without going to the third statement, we can mark our answer as 1 and 3. But we will analyze the third also. So the third says that any public minded person can be petitioner to move the court to obtain the writ of quo warranto. Yes, the quo warranto. Now it talks about the public minded. So it means it is talking on a PIL. So it says that through public interest litigation, a writ of quo warranto on a basis of public interest litigation, court can issue writ of quo warranto. Yes, not only quo warranto, but any writ under Article 32 or 226 can be issued on a basis of public interest litigations. So, for the violation of fundamental rights, three ways to approach the court. The first, the affected persons, affected individual or affected persons. It means the individual whose rights is impact, whose rights is violated. So he can move to the judiciary for the issuance of writs, or through a PIL. If the person who has been affected, it may be an individual or a community, so by any means he is not in a position to move to the judiciary for restoration of his right, by maybe an economic conditions, or maybe like that he is having no knowledge related to any such law that court can restore his right. So any public on behalf of that individual or community can move to the judiciary for restoration of the right. And the third one is suo motu, that is judiciary by their own, without having a petitions from either affected or PIL. If they come to the notice to the judiciary that some individuals or communities right were infringed and no one is doing anything, so suo motu can also be taken by the judiciary to restore the fundamental rights. So this is also true. So our answer is 1 and 3 only. Clear? So let's see. So as we have already discussed, that according to Article 32, the Supreme Court can issue writs such as habeas corpus, mandamus, prohibitions, quo warrantos, and certioris. Now mandamus means we command, that is to command, to give an order issued against officials who have failed to perform his duty or refuse to do his duty to resume his work. So if any officials, public officials, and if the public official refused to perform his duty, or he is failed to perform his duty, so the court will ask him to resume his work, to do the work. Mandamus cannot be issued in the following cases. So when the mandamus cannot be issued, so first, to enforce departmental instruction that does not possess statutory force, to order someone to work when the kind of work is discretionary, not mandatory, to enforce contractual obligations. Mandamus cannot be issued against the Indian President or Governor, against the Chief Justice of High Court or acting judiciary capacities, and also not against private individuals. Individuals or private organization, unless and until that body is having any kind of public nature office. So this is mandamus. Now if you see the quo warranto means, so quo warranto means by what authority the Supreme Court or High Court issue this writ to prevent illegal aspirations of a public office by persons. Through this writ, the court inquires into the legality of claims of a persons to public office. So through this square into, actually it is the court will inquire into the qualification. That's why it is said by what authority, by under what qualifications a person has acquired the office or is chaired the office, right? By what qualifications? Now to understand this, you can take one example for the Q and that suppose you are traveling in a train, and a RPF person, that is Railway Protection Force, one of the member of this RPA, come to you and ask for your ticket, that please show your ticket, right? So you can ask to him that under what authority you are asking a ticket, because it is the TTE who is responsible to check the ticket. It is not an RPF person to check your ticket. So under what authority? So this is an asking that under what authority, by what qualifications. Do you have a qualifications to check anyone's ticket? No, so you cannot check the ticket. So this is one of the example to understand a Q warranto. So through this, the court inquiry into the qualifications, by what authority you are holding the chair, right? And if the person has no qualifications to hold the chair, so the court will ask him to vacate the chair. Clear? So now it says that issued only when the substantive public office of a permanent character created by statutory or by constitution is involved. It cannot be issued against private or ministerial office. Clear? So this is a writ of prohibition, mandamus and quo warrantos. Now we'll move to the next question that was asked in 2021. 2021. So let's see the question. Consider the following statement in respect of Bharat Ratna and Padma Award. So Bharat Ratna and Padma Award are titled under Article 18 Clause 1 of the Constitution. No, this is not true. Article 18 Clause 1 does not talk about any rights or any award. It only says that the state cannot confer any title to any individuals other than the military and this academic award. So this is incorrect. We need to find not correct. So our not correct may be A, C or D. B cannot be the answer. Now if we see Padma Awards which were instituted in 1954 were suspended only once. This you may have idea or not, right? So basically this question is a combination of combination of concept plus fact. So with respect to B, you may be you are knowing or not. That depends. So, but this is also not true. The number of Bharat Ratna award is restricted to maximum of 5 in a particular year. No, this is also not true. This is restricted to 3 in a year. But there are two occasions when it was broke, that recently broke in 2024. So we'll see this. So our answer to this question is D, that is all the three is incorrect. So we will discuss each of this, how this all the three is incorrect. So let's start with the first options. So first option talks about the Bharat Ratna and Padma Award are titled under Article 18 Clause 1 of the Indian Constitutions. So let's see the Article 18, what the Article 18 talks about. So Article 18 Clause 1 of the Indian Constitution prohibits the state from conferring titles on anyone except military or academic distinctions. So Article 18 clause 1 does not talk about Bharat Ratna or a Padma Award. It only talks about any kind of title it cannot be conferred, but military title can be conferred by the state or academic title like PhD holder, right, or bachelor degree, any kind of academic, military colonel, captain, any kind of military title can be given. But other than this, no title can be given. Article 18 clause 2 of the Indian Constitution talks about that no citizen of India can accept a title from foreign states. So this is restricting the citizen of India from accepting any kind of title from the foreign state. Article 18 clause 3 of the Indian Constitution talks about that no person, it means who is not an Indian citizen. So it is about a foreigner, is talking about the foreign nationals. So no person who is not an Indian citizen can accept a title from foreign state while holding a state office of profit or trust without the president concerned. So this article 18 clause 3 is tried to, through this it wants that loyalty towards Constitution of India and towards India should be established, that the person who is employed under or holding any office of profit or trust under government of India or state government should be loyal towards the government of India. So it says that without the permission of president they cannot accept any kind of title, foreign title, right? Now Article 18 clause 4 talks about that of Indian Constitution, says that no person holding state office of profit or trust can accept the title, present, emolument or office from a foreign state without the president concerned. So this no persons include the citizens also plus non-citizens also, that is alien also. So it says that any person whether being a citizen or alien, if the person is holding any state office or office of profit or any trust, they cannot accept any title, present, emolument or office from a foreign state without the president's consent. So this is also, this clause is also try to establish a loyalty towards, allegiance towards the Indian government or Indian constitutions. Clear? Now we will discuss the, this is the first, what we have discussed about the first options. Now let's discuss the second and third statement. So we'll move to the national award. So under the national award, we have discussed, we have the two types of award, Bharat Ratna and Padma Award. So we'll discuss separately. So first, let's discuss the Bharat Ratna. Bharat Ratna, the highest civilian award of a country, was instituted in year 1954. Any person without distinction of race, occupations, position or sex is eligible for this award. So no discrimination is made while awarding the this award. It is bestowed upon individuals who have made exceptional contributions to the nation in various fields such as arts, literature, science, and public services. The government in 2011 expanded the criteria to include any field of human endeavors. The recommendations for Bharat Ratna are made by the Prime Minister himself to the President. So the ground to, or on the ground to award a Bharat Ratna are arts, literature, science, and public service. This was the originally in 1954. In 2011, a new field was added, that is any field any field of human endeavor. And by adding this, the Sachin Tendulkar was awarded a Bharat Ratna through this, under this category. Yeah, and recommendations made by the Prime Minister to the President. Now, on conferment of the award, the recipient receives a sanad. Now, what the recipient will get? So it will give a sanad, that is certificate, signed by the President, and a medallion. The award does not carry any monetary grant. So there is no money given with the award, only a certificate and a medal. The medallion is designed like the leaf of a peepal tree with a sunburst in the center, and a Bharat Ratna is engraved underneath. On the backside, the emblem of India is embossed and Satyameva Jayate is inscribed in the Devanagari script. So this is a descriptions made and the medallion. The rule of maximum 3 awards in a year is a guideline for the Bharat Ratna. So maximum a 3 awardee can be given in a year. The question says that this is the 5, maximum of 5. No, maximum of 3. So because of this it is wrong. But here is also one exception. The rule of maximum 3 award in a year is a guideline for Bharat Ratna. The rule was broken twice in history. So as we have seen that twice it has been broken. One is recently in 2024. The first time in 1999 when 4 recipients were conferred the award. Jayaprakash Narayan, Amartya Sen, Gopinath Bordoli and Ravi Shankar. So the first it was broken 1999, and the second the rule broken in 2024 when 5 recipients were conferred the award. Karpuri Thakur, Mankombu Sambasivan, Swaminathan, M.S. Swaminathan, P.V. Narasimha Rao, Lal Krishna Advani, and Chaudhary Charan Singh. So in 2024, the 5 awardees were given. So this is the second time when the rule is broken. It has been conferred on one naturalized citizen, that is Mother Teresa. So Mother Teresa has acquired a citizenship of India through naturalizations, and 2 non-Indians, Abdul Ghaffar Khan, born in British India and later a citizen of Pakistan, and also known as a Frontier Gandhi, who has started a Khudai Khidmatgar movement or a red shirt movement. You might have studied under the history. And Nelson Mandela, a citizen of South Africa. So 2 non-Indians who are not a citizen of India were granted a Bharat Ratna, and one naturalized citizen of India, that is Mother Teresa. till 2024 there are only 53 recipients of Bharat Ratna award. It's clear? So this is related to Bharat Ratna. Now we will see the second national award, that is Padma Award. So Padma Award, announced in 1954, are one of the highest civilian honor of India, announced annually on eve of Republic Day. The awards the awards are given in three categories: Padma Vibhushan, Padma Bhushan, and Padma Shri. Padma Vibhushan for exceptional and distinguished services, Padma Bhushan distinguished services of higher order, and Padma Shri distinguished services. The award seeks to recognize achievements in all fields of activities or disciplines when an element of public service is involved. The Padma Awards are conferred on the recommendations made by the Padma Award Committee, which is constituted by Prime Minister every year. The nomination process is open to public. Even self-nomination can also be made. The awards are presented by of India, usually in the month of March or April every year, where the awardees are presented a Sanat certificate signed by the President and a medal. The recipient are also given a small replica of medallion which they can wear during any ceremonial or state functions. If the awardees so desire, the name of the awardees are published in Gazette of India on the day of presentation ceremony. The total number of awards to be given in a year, excluding posthumous award and NRI foreign, should not be more than 120. Clear? Next, the award seeks to recognize works of distinctions and is given for distinguished and exceptional achievement service in all field of activities. As illustrated, list of the field is given under. So it can be given under the art, include music, painting, sculpture, photography, cinema, theater, for social work also, including social service, charitable service, contribution in community. For the public service, public affair, including law, public life, politics, science and engineering, that includes space engineering, nuclear science, information technology, research and development in science and its allied subject. Trade and industry includes banking, economic activity, management, promotion of tourism, business. Medicine includes medical research, distinction or specialization in Ayurveda, homeopathy, Siddha, allopathy, naturopathy. Literature and education includes journalism, teaching, book composing, literature, poetry, promotion of education, promotion of literacy, education reform. Civil service, including distinctions and excellence in administration by the government servant. It means government servant are also eligible to have an Padma Award. Sports, including popular sports, athletes, adventures, mountaineering, promotion of sports, yoga. And the last is other, that is miscellaneous fields not covered above and may include propagation of Indian culture, protection of human rights, wildlife protections, and con- conservations. So this is a detailed descriptions of awardees. Through also this we can see that this is also true because none not it been suspended anytime. So all of the three of the given statement is true.